to a biological woman and biological sex. The judgment has implications for many organisations. The Equality and Human Rights Commission has issued interim guidance. For example, in workplaces and services that are open to the public, trans women, those people with gender recognition certificates and those without, shouldn't use women's facilities such as toilets or changing rooms. We're looking at the practical dilemmas this ruling creates for organisations, businesses and individuals. On Monday, we heard from the barrister Robin Moira White, a trans woman and activist who specialises in taking discrimination cases. On Wednesday, it was the turn of Sex Matters, one of only 4 organisations allowed to present arguments and evidence in the appeal. They're called interveners in this instance. Another of those intervener organisations was Amnesty International UK, and its CEO is Sasha Deshmukh, who joins me now in the studio. Welcome, Sasha. It's been a month since the ruling, so I think we should start by finding out what your members have been telling you about the impact of this hearing.
Thanks so much for having me on the programme, Anita. We have been hearing from a number of people, trans people, who sadly, and this has been a long-standing issue in society in the UK and around the world, are very fearful, facing discrimination, facing harassment. That was one of the reasons why Amnesty International put evidence in front of the Supreme Court. You know, we work on human rights all around the world. We believe in everyone's right to privacy, a family life, to be protected from discrimination, and wanted to make sure that the Supreme Court heard those arguments. I think the judgment in this case was a long judgment. It was about 30 pages or so, lots of detail, and the court was quite precise on what it was making a judgment on, and indeed things that it also wanted to see, like discrimination against trans people, absolutely not allowed in the law. Perhaps some people are kind of rushing to judgment as to what exactly the judgment means, how to implement it. And I'd urge some caution, because I think that's causing a lot of fear, a lot of anxiety, and even a sense of threat for a lot of trans people at the moment.
What have they been saying to you?
Well, sometimes we're hearing things, actually, it's important to recognise are really important and good. So, for example, we've heard recently from a number of organisations that run refuges for people who have been affected by domestic violence. And we should remember trans people, sadly, are very affected by domestic violence, as, of course, are other women. And those people have said, we know how to run our services. We know how to protect people in those services. We know how to safeguard. We do that for all individuals from other individuals. Those are protected before this judgment. They still are now. Nothing changes. We're open for trans people. That is really important, and it's very welcome that we're hearing that. We're also hearing people, trans people, saying things like, I don't know whether I can go to the gym anymore. I'm afraid even to leave my home, because actually people are using the judgment perhaps as an excuse to abuse me on the street, which of course is not what the Supreme Court said should happen. So that sort of implication from the judgment, I think now we really need to see some calm and emphasis on the protection of trans people, which the law very clearly says.
You link to Stonewall on your website, and you say that you're proud to work with them and other organisations such as Mermaids and Gendered Intelligence. But according to Aqua Reindorf, who's a commissioner at the Equality and Human Rights Commission, no trans rights organisations applied to be interveners. Were you surprised by that?
Well, we obviously apply to be an intervener ourselves because we've got a great deal of human rights expertise. And I was a little bit surprised that the Supreme Court didn't hear from any trans people themselves in making the judgment. But if you do read that judgment, I think what's also really important now it's been made is, in its length, those parts where the Supreme Court talked about the importance of protection of trans people from discrimination, from harassment, that being very, very clear in the law. So that's, I suppose, what I'm really now hoping that people don't forget in the debate after the judgment too.
We did invite Stonewall onto the programme to give their reaction to the ruling and to reflect on its implications, but they declined. And on what you were just saying, the former High Court Judge Victoria McLeod and academic and activist Stephen Whittle, both of whom are trans, applied as individuals to be heard and were turned down. Aqua Reindorf, who I just mentioned is one of the EHRC's commissioners, said the Supreme Court does not hear evidence about lived experience. It considers legal arguments, thus an individual is never likely to get permission. We had Helen Joyce from the organisation Sex Matters on the programme this week, and she said trans women are men. That's what the Supreme Court confirmed. What's your response to that?
Well, again, I think if you actually read the judgment, 30 pages. It's got points in that really very clearly say that that's not an accurate representation of what the judgment said. The Supreme Court made a judgment on the definition of the words women, and indeed then by implication men, in the Equality Act, in a very specific piece of legislation. But the Supreme Court itself, in its judgment, made very, very clear that it was not saying that what was being litigated was the meaning of gender in wider society. And so, for example, for anyone listening who's worried that if they're in their workplace and someone would come to them and not call them by the pronouns that they've asked and think that the judgment has removed that protection, that's absolutely not true. And that sort of comment, not just maybe what happened on the show earlier in this week, but maybe that kind of misunderstanding of what the judgment is saying, I think's very dangerous. The law's very clear about those protections, including, for example, Anita, I believe that I should call you by the pronouns that you would like. You're protected here in your workplace. The law very importantly protects you on that. But just perhaps more broadly in this debate, I believe that that's polite and kind and respects your humanity. And so we don't need the law to also perhaps remind all of us that we should treat each other with that kind of respect too.
Isn't Helen just reflecting what the judgment has stated, that the word women means biological women?
The judgment stated that in relation to that word in the Equality Act, but the Supreme Court was very, very clear to say that it wasn't litigating on the broader question of gender identity in society. So I think that for someone to say that the judgment and what it said about that specific word in the Act has that implication more broadly, maybe their point of view of what they would like, but I don't think it's actually an accurate representation of the judgment.
You believe this is a human rights issue for trans people. That's why Amnesty International UK got involved. But others would say that women's rights are also human rights. And if the two sets of rights can't be balanced, then the ruling means women's sex-based rights should now be prioritised. What's your view on that?
Well, women's rights are human rights. Human rights are universal. All people have human rights. All of us deserve the right to privacy, family life, protection from discrimination, and indeed wider rights, which are human rights as well, such as access to adequate social security, healthcare, etc. It's often the case in history that people who have a particular point of view try and say that one person, one group's set of rights can only be protected at the expense of others. That's not what we believe. And I think, again, I just sort of remind people the levels of persecution, violence, discrimination faced by trans people, less than 1% of society, but even perhaps the level of attention and noise and debate has shown how much that particular community is being targeted. I would just remind people that the protection of everyone's human rights does not require one group's human rights not to be respected. And certainly now, absolutely, the law is clear, and indeed any reasonable interpretation of human rights is clear. Trans people cannot be discriminated against, and they certainly can't be discriminated against because that's allegedly protecting someone else's human rights.
The interim guidance from the Equality and Human Rights Commission states that in workplaces and services that are open to the public, trans women or biological men should not be permitted to use the women's facilities, and trans men or biological women should not be permitted to use the men's facilities. And this will mean that they no longer single-sex facilities and must be open to all users of the opposite sex. However, where facilities are available to both men and women, trans people should not be put in a position where there are no facilities for them to use. What's your advice to trans women? What should they do?
Well, I think one thing to remember in relation to that interim guidance, it's an excellent question that you ask. That guidance was put out by the Equality and Human Rights Commission very quickly. It's actually not statutory, that particular guidance, and the Equality and Human Rights Commission is consulting and indeed had to extend its consultation from perhaps some of its initial plans, because it's really important that it takes into account those aspects of the law the Supreme Court emphasised on the lack of discrimination. I think my advice, not just to trans people, but perhaps more broadly, service providers, etc., is not to rush to judgment on what the court case says. And indeed, that Supreme Court, Equality Commission guidance that will come after the consultation will be important to see. the law continues to say that actually the bar to excluding people is a high one. It has to be proportionate, it has to be legitimate. That's perhaps why we've seen, for example, those organisations running refuges saying, no, we absolutely can continue to serve people. So I think a lot of people who might be rushing to say trans people should be excluded as organisations are actually putting themselves at risk of being challenged in the law on discrimination.
Well, they're only following what the interim guidance is telling them.
I think, again, the interim guidance is not statutory. So
you're telling them they shouldn't follow it?
Well, I think that it's going to be really important to see how the Equality and Human Rights Commission takes into account everything that it hears in the consultation and produces quality guidance that does represent those anti-discrimination points. What I would certainly advise any organisation to do and to make sure they're doing is they continue to respect the law on the protecting trans people from discrimination or not having access to services, because that's just important for any organisation to do.
Sasha, when there's such diametrically opposed interpretations of the same ruling, what are people and organisations supposed to think and do?
It's a really excellent question, and of course the law is a complex thing sometimes for anyone to absorb. I think my advice would always be to any of us, including ourselves, a judgment that's this long, 30 pages, with this much detail in it. I think a critical thing for us all not to do is to rush to judgment, or perhaps, if people have a particular point of view on the judgment, to make a statement or an implication beyond that the judgment makes. We now all need to have things like high quality guidance that's properly taken into account, consultation, including, of course, with trans people, to ensure that the protection from harassment, discrimination that's there within the law continues to be respected. And perhaps people who are rushing to say, it definitely means this or it definitely means that, I think that's a difficult thing for anyone to do with any real confidence from any judgment, let alone one this complex.
I want to use a real-world concrete example, if I may. We know a group of female nurses in Darlington are currently taking their trust to tribunal for allowing a trans woman to use their single-sex changing facilities under a policy of transitioning in the workplace. Why do you believe trans women should be in these spaces?
I don't know the specifics of the changing facilities in that case, but even to use that particular example that you said, for example, if changing facilities or any other kind of facilities are a space with safeguarding, with the right protections for people, regardless of which is any other person that's coming in that space, that's what anyone deserves from any kind of space. I think what I would be reminding people of is this point about the proportionate legitimate need for the exclusion of anyone from any particular service or facility. So again, places that may have a large throughput of people, places where actually any facility is a private space for changing or anything else. What would be the argument for the exclusion of anyone from that? There's obviously in any space, any public space or any private space that any of us are in, we should be protected from any kind of threat or any danger. Perhaps, again, in this big debate that's happened about 1% of people within society who are trans, we shouldn't forget that 80% of the violence targeted at women, much, much too high overall levels of violence, but 80% of that is from partners, ex-partners or friends, the overwhelming amount of which, sadly and tragically, is from cis men who identify as men. So that's the point that I would make about all facility services. We have an obligation, any of us running organisations, including public organisations, private companies, etc., to make sure those services are provided to trans people who cannot be excluded from them. And we need to take that into account in the way that those services are designed and provided. And that has not been affected or changed by this judgment. If anything, the Supreme Court reminded us of it.
But what about the privacy of biological women?
Privacy is something that all people deserve. Privacy is a right for any of us to have. I'm not sure why I can quite see the argument that the privacy that any individual deserves in their own life is any more or less required versus anyone from any other different background. I can't quite see the argument myself as to why the exclusion of some people from services, from facilities, is required for any of us, whichever identity that we may have the privacy that's our right.
Sasha Deshmukh, thank you very much for coming in to speak to me this morning from Amnesty International UK. On Monday, Nuala will be hearing from the LGB Alliance, who also submitted evidence to the Supreme Court in this case. And if you missed our previous interviews with the barrister and trans woman Robin Moira White and Sex Matters Director of Advocacy Helen Joyce, you can catch up on BBC Sounds by listening to the 12th and 14th of May episodes of Woman's Hour. That text number, once again, 84844. Now,